and we are going to start with just a basic introduction of the Attorney General's office. What you have on the screen right now is our boss, the Attorney General herself, Maura Healey. She's the Chief Lawyer and Law Enforcement Officer of the Commonwealth of Massachusetts. And that means that if you are a resident of Massachusetts, as long as you live in the state of Massachusetts, we represent you and we represent your rights and your responsibilities as well. Who is the Attorney General's office and how do we serve? Like I said beforehand, we represent the Commonwealth as a whole. As long as you're a resident, we represent your public interest. We also represent groups of consumers. We do this through different ways and through different avenues throughout our office. We look at workers' rights situations. We look at different immigration situations. We look at consumer situations. We look at things from insurance and financial services and environmental issues and everything in between. So if there is an organization or is there some type of issue that is affecting a group of people in Massachusetts, our office will actually investigate that if it comes under our purview. A lot of times we also get questions about, hey, you're the Attorney General's office, you have Assistant Attorney Generals, can they represent me on my individual cases? Unfortunately, we cannot do that, and there's a multitude of reasons, but one of the reasons is that in many cases we actually do represent departments, officers, and commissions. It's a part of our constitutional role as well, so we cannot represent individuals. How we do this, how do we serve the Commonwealth of Massachusetts? We do this through 4 different ways. 2 of them are kind of your traditional law enforcement way, right? We do investigation, we do enforcement, we have assistant attorney generals, we have mediators, we have investigators, we have paralegals, and we have a lot more in our office that make sure that laws in Massachusetts are abided and make sure that if there are any bad actors, that we are looking into that and we're investigating and we're enforcing the laws. But we also do this through two more innovative ways, and that's through prevention and policy work. Prevention is kind of like today, where we let organizations, nonprofit organizations, businesses, individuals, and community members know about their rights and also their responsibilities under the Massachusetts general laws to make sure that they know about what's expected to them, or make sure they know about what their rights are, and try to prevent the laws from being from not being executed properly. We also do this through policy work. We receive a lot of different complaints, a lot of different consumer complaints, and we have a lot of interaction with the public. That interaction, along with what we hear from people like you, goes into our policy work, and we see if some type of statute or some type of policy is not working correctly in Massachusetts, or that we can enhance it or make it a little bit better. Our office can actually advocate for that at the State House as well. So those are 2 ways that we try to innovate in terms of public policy in Massachusetts. Sorry about that. I don't know if you can see that. Got a little bit of a... Sorry about that. Where is the Attorney General's office located? So we're not just in Boston, although we do have 2 offices in Boston right next to the State House at 1 Ashburn Place and 100 Cambridge Street, but we have offices throughout Massachusetts. We've got offices in downtown New Bedford, in downtown Worcester, and downtown Springfield. But we also have our division, Tim and I's division, called the Community Engagement Division, where we're trying to take the resources of our office and bring them to different areas throughout the state. So if you have an issue in a Lowell or a Leominster or a Pittsfield or on the Cape, we can actually bring assistant attorney generals, mediators, investigators, or members of the community engagement team to either help out with filing complaints or just to let people know about their rights let them know about the responsibilities, and give out trainings as well. So we can do that be in the morning, we can do that at night, we can do that on holidays, we can do that during the weekends, wherever and whenever the community is best served, we are there. So we're not just in our Boston, Worcester, Springfield, New Bedford office, we're everywhere throughout the Commonwealth. And like I said earlier, we have a Public Protection and Advocacy Bureau. It's kind of our most outward-facing bureau, which has a lot of different consumer-facing departments, things like our Consumer Protection Division, which can help you out with consumer issues and the things of the sort. We have a Fair Labor Division that looks into workplace rights issues, make sure that workers' rights are upheld. We have an Insurance and Financial Services Division. They work with our student loan assistant unit, and they can actually help you out with different resources that are available in terms of student loans. We have a Civil Rights Division that upheld civil rights in Massachusetts and makes sure that protected classes stay protected and that civil rights infractions do not happen. And our Consumer Advocacy and Response Division, which we call CARD, is usually your first entry into our office, and they kind of look at all different types of consumer issues. There's a lot of mediators and there's a lot of different investigators in that division that can help you out with consumer issues. And with that, we're going to get into landlord-tenant rights. That was a brief introduction of the Attorney General's office, but we're going to get more into the basics of landlord-tenant rights. Before I get into that, have we received any questions about the Attorney General's office and what we do? No, it doesn't look like we have. So I'm going to give the baton to my colleague, Tim Deppen, who is going to speak more in depth about landlord-tenant issues. Thank you, everyone.
Thanks, Bongani. Thank you for that overview of the work of the Attorney General's office. And of course, if you do have a question for a later date, you can always send that in to us on anything that Bongani just presented, and we're happy to answer that again. So, landlord-tenant rights, I hope you'll excuse the pun that we have on this slide. How's it all work anyway? Just a little fun. As Bongani has mentioned before the presentation really began, just one point I want to reiterate is that this is a basic overview of landlord and tenant rights, specifically tenant rights and landlord responsibilities. You know, we're going to do to the best of our ability to answer the questions that you may have. We have Matt Burge here as well to help us out with that, but it may not be everything that you're looking for. So if you didn't get what you were looking for in this presentation, please just let us know afterwards, and we can try to direct you to some other resources where you may be able to find those answers, because we're committed to making sure that everybody gets the information that they're looking for. So to begin with, and we start with a very basic breakdown of what we call the two types of tenancy here. And also, just so everyone's aware, I have seen some of the questions that have come up in the chat so far. Those are issues that are covered on another slide. So when we get to that, if I have not answered your question or answered the question to your satisfaction, please let me know at that point. Just feel free to jump in the chat again, and I will hopefully spend a little bit more time on it, or maybe Matt will help me out with the answer there. So to begin with, the two types of tenancy, right? The most simple breakdown that we have here is a tenancy that can be based on a lease and a tenancy at will. So to begin with, a tenancy that's based on a lease is, as what it sounds like, it's a written lease, right? The terms of the tenancy are written down and signed by both the landlord and the tenant. It lasts for a specified amount of time, something, again, that is written down in the lease. It could be a year, it could be 18 months, it could be 6 months, it could be 3 months, but it's written down how long the tenancy lasts, and the rent stays the same during the lease period. So the other major part of the agreement as well with the time constraint is how much is going to be paid per month, right? So if you sign a tenancy that's based on a lease, you sign a lease for 1 year and you're going to pay $1,000 a month for that apartment over the course of the year. You can't get 6 months into that 1 year lease and have the landlord change the amount of rent because something has changed. They decide they need more money. They realize that they were undercharging you, right? They sign that lease. Now, after the lease is over, before signing an extension of the lease or signing another lease, those are times where rents can go up and down or terms can change, but not during the period of the lease. That is opposed to a tenancy at will, which sometimes has a very basic written agreement. Sometimes there's no written agreement at all. It lasts as long as both parties want to do business together. So for as long as the landlord wants to continue renting to the tenant, and for as long as the tenant wants to live there, right? Wants to rent this apartment, this house, whatever it may be, from the landlord. And the rent can change with 30 days notice. So with 30 days notice or 1 month before the next rental payment would due, whichever is longer. So usually that's going to be 30 days notice. So unlike a tenancy based on a lease, if a landlord discovers that they've been really undercharging, or a tenant discovers that they've been really overcharged by a landlord, and they want to change the terms of that tenancy, they want to change the terms of how much they're going to have to pay, they can do that with 30 days notice, right? And that's also the same for leaving. And we get into this a little bit more on a slide on eviction later, but a landlord can inform a tenant 30 days ahead of time that they intend to end the tenancy when it is a tenancy at will, as opposed to that tenancy that's based on a lease, where there are obviously going to have to be more steps that the landlord's going to have to go through to end that tenancy early, right? There would have to be some sort of violation of the lease for the landlord to be able to end that tenancy. So if we go to the next slide. So obligations of the landlord and tenant, again, this is just a very basic overview, right? What is the tenant responsible for? What must the tenant do? Well, the tenant has to pay rent, pay the rent that was agreed upon, and follow any rules agreed upon with the landlord. Now, there are some terms that a landlord is not allowed to put in a lease, but generally, right, if a tenant agrees to something in a lease, that they should follow those rules. They have to continue following those rules so they're not in violation of the lease. And accept responsibility for damages beyond the normal wear and tear. Now, we get this question a lot, what constitutes normal wear and tear? And I mean, really, at the end of the day, it's difficult for us to say with any certainty, right? If you follow sort of the string, you really dispute it all the way up to court. It's going to be up to that judge to decide what constitutes normal wear and tear, what is beyond normal wear and tear. But essentially, anything major, right? The tenant has punched a bunch of holes in the wall, right? The tenant has dug up part of the floor, right? That's obviously things that are beyond the normal wear and tear and are the tenant's responsibility. The carpet that's a little bit worn now, that's living in a place, right? That's living in an apartment, that's living in a house. So that is something that would most likely fall under normal wear and tear. We do have a question here about the previous slide that I was just on. In a tenancy at will, how many times can the landlord can increase the rent in a year period? Again, I mean, I guess theoretically the landlord could increase it 12 times, right? Because they can do so with 30 days notice. Now, again, there's always the push-pull there. If the landlord increases it too far, perhaps the tenant doesn't want to rent from them anymore, and instead of getting $1,000 a month that they were trying to increase it to, they get $0, right? So theoretically, the landlord could increase it 12 times during a year, though I don't know if Matt has. I've never heard of something happening that often.
No, I've never heard of that happening, but I would give a little practice tip. If your landlord is raising the rent to an exorbitant amount because he or she is trying to get you out for some unlawful reason, for instance, they don't want to rent to families with children, or they are basing their animosity based upon your race or your gender, or any other protected category. Say they raise it from $1,000 a month, I'll give an extreme example, to $10,000, and you believe they're doing that to get you out for an unlawful reason, they can't do that.
Yeah, so I'm just noticing a couple more questions here from the previous slide. For a tenancy at will, is there a minimum period of notice that the party must give if they want to end the tenancy? 30 days, yes, 30 days, that is correct. So when we get to the slide on eviction, you'll see something that's called the 30-day notice to quit. That is what the landlord must give to the tenant. It essentially says, hey, I want you out of here in 30 days. Now, if the tenant doesn't leave at the end of that 30 days, right, that's when you might get to the eviction process in court. And unfortunately, we're not able to talk about that too much because that's not an area where our office can really be of assistance because, as Bangani said, we can't represent you legally. We cannot be your attorney. So that being said, we will touch on that a little bit. on the slide. Another question, how long of notice should you give a tenant if you are looking to sell the property? I mean, there are sort of two questions within that, right? How much notice must you give the tenant? Well, if it's a tenancy at will and you want the property to be vacant when you sell it, then again, that's 30 days notice. If it's a tenant with a lease, you're going to have that tenant till the ends of the terms of the lease, and you should know that as you're trying to sell your property. Now, how much should a landlord give? I mean, ideally, a landlord would give the tenant the most notice that they can, right? I mean, you hope that there's a cordial relationship there.
You got to keep in mind, if you have a written lease, you're trying to sell your property. You're selling the property subject to the lease that's already binding you on the property. So if you're going to sell something free of tenancy, you got to make sure the tenancy is over before you close on the property. So in theory, you may have a situation where you make a deal with a buyer. I'm going to sell you my property, but I have this existing lease you have to take on.
And just one more question, I'll jump back to the slide I see here. I assume this means, do undocumented immigrants have the same rights as documented immigrants or people who were born here? And the answer to that is yes, and we will talk about some discrimination issues on a later slide, but the answer to that is yes, though I think unfortunately many undocumented immigrants are subject to more threats and more discrimination in the housing context. So I talked about what the tenant must do, and again, if there are any questions that come up, please let me know. What the landlord must do is provide an apartment that's safe, clean, and compliance with the state sanitary code. We'll talk about that a little bit more on another slide, but again, I mean, that's pretty obvious, right? If you're renting an apartment, you're renting a room, you have to make sure that it's habitable, you have to make sure that somebody could live there, and live up to promises that are made in the lease and the rental agreement, right? So if in the lease, you sign a lease with the landlord, and the landlord says, I have this driveway next to the apartment that you're renting, you get X spot, right? You get this spot, and you'll get this spot that's part of your lease. And then the landlord decides, oh, that actually is a nicer spot than the spot where I park my car. I'd rather park in that spot. That's not living up to a promise that was made in the lease. That landlord agreed in the lease that you would get that parking spot, right? And there's also, the landlord says that it's the landlord's responsibility to take out the trash every week. And then the landlord tries to say, oh, well, actually, that's going to be the tenant's responsibility. Again, if the promise is made in the lease, it's up for the landlord to live up to it. So another thing, some things that must be on the terms of the rental agreement, you're going to need the name, the address, and the phone number of the owner of the property. The person who's responsible, and again, this could all be the same person as we're looking at the slide, keep that in mind, but it may be different people. The owner of the property, the person who's responsible for maintenance if something goes wrong, who do you call, and the person to whom the tenant can give copies of formal notices, complaints, court papers, right? We'd hope it doesn't come to that in the tenancy, but if it does come to the point where the tenant has to serve legal notice to the landlord or to the property management company, whatever it may be, they're going to need to know exactly who to send that to. So that's going to have to be included in the terms of the rental agreement. And on to the next slide. So this is a question that I've seen a couple times, a couple different ways, and we can spend a little bit of time on this slide. What is the tenant forced to pay? What does the tenant have to pay at the start of the tenancy, right? What can the landlord ask for? And there are 4 things that the landlord can ask for. They can ask for first month's rent and last month's rent. And there are laws regarding security deposit, which I'll mention later, and the last month's rent that we can talk about a little bit more. They can ask for a new lock and key fee. Essentially, the landlord is changing the locks because from the last tenant to the new tenant. And they can ask for the security deposit, right? And all of these, none of these, the security deposit specifically, can exceed 1 month's rent as that security deposit, right? They can't say, the security deposit is $15,000, right? Something exorbitantly expensive that the tenant would not be able to afford. These are the 4 things that the landlord can ask for at the start of the tenancy. Now, what I think many people are going to say is, and anyone who has tried to rent, especially, I'll speak for myself in the Boston area, is you almost always end up paying a realtor or broker's fee in addition to that, right? When you think about payments at the start of tenancy, you do think of 4 things, right? But you think of first, last, security, and a realtor's broker's fee, which doesn't go to anything, right? Doesn't go to anything to do with your tenancy. That's in a slightly different category because it is not a payment that's going to the landlord. It's a payment that's going to the real estate broker, the real estate agent, the finder's fee, whoever it may be who connected you with the apartment. So again, I put that in a slightly different category. We also got a question about other things that that real estate brokers may charge. And yeah, that's a good question too, and not one that I want to speak too forcefully on, because I know the major thing that I think most people are charged for is the fee for a credit check, to check your credit when you are applying for an apartment, applying for a house that you are going to rent. I don't want to speak forcefully on it for a couple of reasons, but the primary one is that there's a bill right now that's at the State House that was signed by the governor, I think went back to the legislature with some changes. They came out in light of the Equifax data breach, so it changed a lot of things around credit reporting and when a tenant may be responsible, or not even a tenant, when a consumer may be responsible for someone checking their credit. So not knowing if that changed anything, I don't want to speak too forcefully on it, but from what we've seen, I mean, that's something that is asked of tenants a lot. It may not be something that's expressly prohibited in any regulation. What does the bill do? I mean, so the bill, the Equifax bill in general, and just to take a slight tangent, the major thing that does, I think, that's helpful for folks if you're interested, is that it makes security freezes and security thaws of your credit, right, not being able to get a hard inquiry on your credit, free, right? Before, a credit reporting agency could charge you for a security freeze or thawing your credit. Now they're not going to be able to, and it did change some other things around how much monitoring companies may be required to give you if you are the victim of a data breach. Right, all this came in light of the Equifax data breach, where half of us may have had our information compromised. Yeah.
Yeah. One of the questions I'm asked a lot is about this credit check issue, and also an application fee, which seems to go to nothing but a processing fee, like you buy a car and they charge you the documentation fee. I have a hard time answering that because I don't know the answer to it, but if you came into the office, I would say the issues are the credit check might be a legitimate part of the background check to make sure you're a qualified tenant, and I would say they should charge it as an additional rent under your lease. But the application fee, the non-refundable application fee, I would have a problem with if you came into the office talking about that happening to you, particularly if you didn't get the apartment and they kept the fee. I would find that very troublesome. That's as much as I can say about it, because I really haven't seen any law one way or the other with a definitive answer about whether or not a landlord or a broker can do that. But it is a constant issue, and just to be aware of it, we want to raise it for you.
Yeah, and a couple more questions that I'm seeing here. Can they charge a lock fee if they do not actually change the locks? I don't know how you would know for sure that they didn't actually change the locks, but I would say is if you're being charged fees for something your landlord is not actually doing, that's something you may want to let the Attorney General's office know about, file a complaint with us. And Matt, I don't know if you'll know the answer to this one. When they increase the rent during the time you live in the apartment, can they also ask you to supplement the original security deposit?
Yeah, if they're legitimately increasing the rent, they can ask you to supplement the security deposit. For instance, if your one-year lease term ends and they say you can sign a new lease for $100 more a month, they can't ask you for another $100 to supplement the security deposit.
They can ask you for, okay. And one other question that I'm seeing here before we move on, how do these rules apply to individuals who live in subsidized housing?
The same rules apply. Well, I can't say every rule we talk about with respect to landlord-tenant law. There are issues concerning subsidized housing that are unique to it, but things concerning security deposits, et cetera, the basics would apply to subsidized housing.
Right, and one more question, Matt, because I think it's something you just touched on. Can a landlord or realtor take a deposit to take the apartment off the market? Right, I think that application fee that you may have been talking about there.
I would have a lot of trouble with that.
Yeah, because that is something, again, this gentleman said they see a lot. I know that personally when I rented an apartment a couple of years ago, that's something that happened to me. He placed that deposit to get it off the market before the whole application process went through.
If you came to the office with a problem, the landlord's doing this, I would say, my question would be, did they give you credit for that deposit when you actually signed the lease? And if you didn't sign the lease, did they give that deposit back?
So some information about the security deposit laws. Some things the landlord must do when they take a security deposit. So, and also the landlord should be prepared to do this if they want to take a security deposit, right? If this is too much for the landlord to do, then they may not want to take a security deposit because this is pretty strict. The landlord must give the tenant the name, the address, of the bank that's holding the security deposit and the account number, essentially, right? So the tenant should be able to see that their security deposit is actually in this bank being held as a deposit and not in, wherever, right? Each year, they must either pay the tenant the interest on the security deposit or let them deduct that amount from a rent payment. Again, that's not likely to be a huge amount of money, right? That's not likely to be something that's going to break the bank for the landlord or be a huge relief to the tenant, but it's something the law says the landlord must do. So it is something that they would probably want to be aware of.
This has some serious consequences too, because if the landlord doesn't follow this rule by statute, the landlord can't deduct anything from the security deposit at the end of the lease term. So landlords and tenants should be aware of this provision. Many landlords aren't aware of this, particularly smaller landlords. So if there are smaller landlords on our webinar, I would urge you to make sure you follow this rule to protect your rights.
So the other thing the landlord must do is give the tenant a statement of condition. Statement of condition form is a pretty standard form, which describes the condition of the apartment and the damage that exists at the time. Now, this is a really key one for the tenant, because if there's something on that statement or there's not something on that statement of condition form, right, there's a huge smudge on the wall, there are holes in the kitchen, whatever it may be, right, it's not listed on the statement of condition form. The tenants want to make sure to add to that form some of the issues that are ongoing in the apartment, in the house, so that at the end of the tenancy, right, that's sort of the proof there that the tenant didn't cause these problems, that these problems are pre-existing. And the landlord and tenant are going to want to be on the same page about that if it does come up at the end of the tenancy.
And this is where you're going to have a dispute with the landlord and tenant at the end of the lease term about normal wear and tear versus tenant's damage. Because there will be things that happen during the course of the tenancy that won't be in that statement of conditions because it's normal wear and tear. My classic example is the grouting on your tiling in your bathroom. It comes loose during your tenancy. It looks awful at the end of the tenancy. So I would suggest to tenants to make sure you let the landlord knows what's going on during the course of the tenancy so they have the option to fix it.
And now we have one question here about the statement of condition. If you receive a blank statement of condition when you're signing a lease, so this is before the tenancy even begins, and they're asking you to sign it. Can you wait and sign that after your tenancy began? Apparently, many realtors are requesting the tenant sign this at the time of the lease. Yeah.
I would definitely tell the real estate broker that I will do a walkthrough and sign it after I do the walkthrough, and make sure you write down everything you see that's wrong with the place.
Right, because this can come up later. And
there are hidden defects too. Keep in mind there's something called hidden defects that you can't see from your by your eyesight alone, that would not be included in this condition of defects. But when you find those hidden defects, let the landlord know about them.
Yeah, and this also gets to another question that I had seen earlier, and I'm sorry we didn't get to it earlier. Sort of the pressure that a tenant feels with realtors and landlords sometimes, because the idea that if they sort of don't give up their rights, that the landlord won't rent to them and somebody else, right, we all know how the Boston real estate market works, right, they'll find a tenant right away, and sort of that unequal playing ground there. Matt, I don't know if you have any tips or anything if somebody faces a situation like that.
Well, it's unlawful for a landlord to not rent to you because you're exercising your rights. That's the law. But as a practical matter, it's going to take you a long time to enforce those rights to get that apartment, and the apartment's going to get rented out from underneath you. It would really be a consumer protection violation, and there are damages available under our Chapter 93A of our general laws. But that doesn't do you any good if you're renting an apartment today. So it's one of those unfortunate situations where there is a remedy, but the remedy might not be available to you immediately to help you out immediately, as far as I can tell.
And that's one question here, and I personally don't know the answer to it. I'm not sure you will either, and if not, we can look this up. Do you know about landlords asking tenants to fill out a W-9 for the security deposit?
W-9.
You heard of that? For the separate bank account.
Banks may require that. I've heard this question before, and it might be the landlord has to report income that the tenant is earning on the security deposit. So I can't answer that question. I'm not a tax expert, but my gut feeling as a lawyer is it would be legitimate if the IRS requires it, because it is income on money you have on deposit with the landlord. It's probably a bank requirement, not the landlord's requirement.
Yep. We got one question back to the previous slide. Just to clarify that there's nothing specifically in law that you've seen in the law or regulation one way or the other about the landlord charging a fee to sort of hold the apartment or take the apartment off the market.
I'm sorry, one more time?
So I think essentially that's what you're saying. There's nothing specifically, no specific statute or regulation about a landlord charging a fee to take an apartment off the market.
I think that would be the basic statute concerning what the landlord can charge at the beginning of the term. So my reaction is the landlord can take that fee to take it off the market, but the landlord would have to give you credit for that fee in your security deposit or your first or last month's rent. And if the landlord didn't rent you the apartment or you decided you didn't want it, the landlord would have to refund that deposit.
Great. So then the one last thing about the security deposit before we move on to the next slide, the landlord has to return the security deposit plus whatever interest has accrued within 30 days of the tenancy ending, or if they're taking some of that security deposit, that they are informing the tenant of that and giving them an itemized list of costs, what they're taking out, why they're taking it out, right? And then the tenant disagrees, right? They can dispute that with the landlord.
Right, but there's one flaw in that statement. I just want to point out that you say you're returning the security deposit plus interest. Keep in mind, you have to be paying the interest earned on a yearly basis or giving them credit for it in their rent. Otherwise, I agree with that statement.
So some information about the Mass Sanitary Code. It requires the place to be habitable, to be able to be lived in, comfortable and clean enough for a person to live safely. The sanitary code violation isn't addressed by the landlord. The tenant can request an official inspect the apartment, inspect the house. That's likely to be inspectional services in some towns, cities or towns. It may be the health department that can come out and do an inspection. And if the landlord still fails to fix the problem, there are some recourses there for the tenant. Now, here on the slide we have a tenant may be able to withhold a portion of the rent or move out. That could be where things end up, but I think we want to really caution that the tenant not just withhold rent without speaking with the landlord, right? Because that can get the landlord actually to start eviction proceedings, and maybe the court finds in the tenant's favor, but it really starts a whole thing. Whereas the tenant speaks to the landlord ahead of time, hey, you didn't fix this issue, I couldn't stay there for however long, my plan is to pay half month's rent, right? And the landlord agrees. That's a different situation than the tenant just saying, well, I couldn't live there for a week, so I'm not paying that week's of rent without discussing it with the landlord first.
Yeah, you as a tenant, if you end up in the housing court disputing the rent that you withheld because of the condition of the property, you'll go a long way with the court if you can tell the court that, yes, I did tell the landlord as soon as possible what the problem was and the landlord didn't fix it. If you go in and say, I withheld the rent because the place was a pigsty and it was not sanitary, and the judge says, well, did you tell the landlord? No, he should have known. I don't think you're going to go a long way with the court.
Yeah, we've got two questions here about that. Where can a copy of the Massachusetts Sanitary Code be obtained? I don't know for sure, but I believe it's a publication of the Department of Public Health, so I'm sure if you went on their website, you could find a copy or some guide about the Mass Sanitary Code.
Right, it's in the Code of Massachusetts Registrar, the CMR as we call it, and you can probably find it on the Department of Public Health's website. The statute you want to reference is Chapter 111 of the General Laws, Section 127, capital letter I.
Yep. One other question. Who do you contact specifically to arrange one of these inspections? It looks like this group is in Waltham, so specifically you would want to call Waltham City Hall, and I don't know if they have an inspectional services department or it's part of the health department, the Board of Health. Somebody there would be able to get you started. The important thing for everybody, right, to understand is that it's going to be done at the local level, right? It's going to be done by the municipality, so it's going to vary exactly who you call depending on where you live, but it's always going to be inspectional services, ISD, Board of Health, something along those lines.
Every city and town has a health inspector.
Yep.
Tim, it looks like we've got another question about in the event of a fire. What is the responsibility of the landlord in terms of assisting tenants with temporary housing or relocation in the aftermath? Is there anything that the landlord has to do?
That's a good question. I'm going to just answer it based upon basic landlord-tenant law. Number one, was there something in the lease about it for that contingency? There probably isn't going to be something for that contingency in your written lease. Two, the landlord, what happens when there's a fire is what we call a constructive eviction. That means the premises are in such a condition that you can't live in them anymore. Therefore, you as a tenant can stop paying rent. that's your right. That's the only right you have under the law. The tenant should get renter's insurance to make sure that they're covered in the event of the loss of a fire. But as far as the landlord's responsibility to relocate somebody, that is nothing I've seen in the law, and I'd be surprised if there's anything in the law that would require that. In fact, I'm very confident that the landlord wouldn't have that responsibility if there is a fire. The tenancy would end.
Right, and just to speak a personal note, a friend of mine actually didn't have a fire in his apartment, but had a fire right next to his apartment, made the apartment uninhabitable for a month. And he came to stay with me, but essentially the landlord didn't do anything to help find any housing there, but he was not responsible for paying rent for that month.
Now, this is one of those situations where you say, well, it might depend on your situation. I can see a situation where the landlord was so negligent that he or she caused the fire by their negligence, in which case you have other damages that you can bring a claim against the landlord for negligence, and that might include relocation costs, but that's beyond landlord-tenant law. And that's an extreme example.
So we have two more questions. Can a landlord, there's I think are slightly related, can a landlord require a tenant to get renter's insurance? I believe that could be a term if they can't require it.
No, they can't require it, but they do encourage it.
Encourage it, right.
But they don't want to get sued.
And can a tenant request that the landlord show their property insurance and see if any funds go to relocation?
You can make that part of your lease term, but there's no requirement that I'm aware of.
Yeah. So I mean, both those questions start with can, and I think the answer is yes. They could ask for it.
If
right?
you agree to it, you could ask for it. Yeah. You could always ask for it. You could always make an agreement to do it.
And retaliation, so this is something that we've talked about, or we've sort of talked around a couple times, right? Landlords cannot evict you for exercising your rights. Now, as Matt has said, sometimes when you exercise your rights, right, in a practical matter, less so when you're actually living there, but more so, in the application process, it can be difficult to feel confident with that. But again, it's important to remember that it is illegal for them to do so, right? And if they try to evict you for exercising your rights, who's to say how far they're going to get in housing court with that, how far they'll get with the judge?
As a practical matter, from our office's perspective, if there is a landlord doing that to prospective tenants, we probably see a lot of this in the student housing area, where they are doing something that's unlawful, and the remedy isn't immediate for the prospective tenant. If we find out about the landlord engaging in that ongoing practice, that's something we would look at here in our office on a broader scale against that big landlord. Individual cases we couldn't handle, but it's worth making the complaint to our office because we do monitor those trends.
So another thing that we've talked about a couple times, and we'll get a little bit more in-depth again, and not super in-depth. I think if you have more questions about the exact eviction process and summary process and how that works, we can try to connect you with a better resource, somebody who spends more time in it to get those questions answered. So the process starts when the landlord files a civil action in court. The landlord is going to have to get the judgment from the court the date that the tenant must leave by, right? What does the landlord giving the tenant? The landlord is giving the tenant generally a 30-day notice to quit. That's how most tenancies are going to end, whether they're at the end of a lease or it's a tenancy at will and they want the tenant to leave. There's also the 14-day notice to quit, and I believe that's specifically for non-payment of rent. I don't know for sure if any other terms can come in there, right? Any other violations of the lease that could come up there, but mostly that's for a non-payment of rent eviction from the landlord. It's just a smaller window for the landlord to start proceedings. Then at that day in court, right, the tenant has right to raise defenses to the eviction, so things that the landlord may have done incorrectly as well. Matt, do you have anything to add on that?
No, not at this point in the eviction process discussion, no. But I think you're right. It's the 14-day notice would be for a failure to pay rent. And that makes sense because a lot of these landlords, not big companies, these are people who have to pay their mortgage month to month, so they rely upon the rental stream. So it makes sense that the law would allow them to have a shorter notice period for non-payment of rent.
Question here, can a landlord provide an interpreter if you don't understand what's written on the lease or translate the lease to the language spoken by the tenant?
The landlord's not required to do that, but the landlord does so at his or her own risk, because if you're giving someone, a consumer, a document to sign and binding the consumer to that relationship with you, whether it be landlord, tenant, or any other business consumer relationship, that tenant or consumer has a defense that they didn't understand what they were signing, and the person who gave it to them knew that. So the landlord does it at his or her own risk.
And again, some things that we've talked about, right? Housing discrimination, it's another issue that our office takes a big look at. We have our Civil Rights Division, who many of these complaints would go to. It's unlawful to deny housing because of a person's race, color, national origin, ancestry. I mean, I don't have to read them all. You can see them all. Any protected class, right? It's unlawful to deny a person housing because of that. And we have here, I believe in April was the 50th anniversary of the Fair Housing Act, so our office recognized that, and we created this flyer from our Civil Rights Division in Massachusetts. It is unlawful for a housing provider to discriminate against a current or prospective tenant, again, based on any of these protected characteristics. And if you have been discriminated against or know of someone who's been discriminated against based on any of these, to file a complaint with the Attorney General's office, to file a complaint with our Civil Rights Division, and they can help you out more with that. Or if you do have any, sort of more in-depth questions about fair housing and housing discrimination, I know that we did put up a whole section on fair housing on the Attorney General's website. So just go to mass.gov, you can search fair housing. You can find some more in-depth information there.
Tim, we also received a question about, is it unlawful to rent to an undocumented immigrant?
No, it is not unlawful to rent to an undocumented immigrant. One might argue that not renting to somebody because of their national origin or their status might be unlawful in and of itself.
Yeah.
Yeah, and we do have one other question here, and again, I'm just going to apologize to everyone that, unfortunately, we've received a lot of questions, which is great. We haven't gotten to every single one of them, and we're starting to run up against the clock, so I just, we can stay a little while longer, or, if there's a pressing matter that, we want to, that you really need answered, you can let us know after the presentation. We can try to get matter or someone to answer that question. One question we have, landlords can discriminate against undergrad students for being undergrads, though, is the question.
I'm going to say yes and no. Part of a good education is the answer to many questions is it depends. I know that a landlord can require a tenant to be credit worthy. So the landlord can require that the tenant has the credit available to pay the rent under the lease term. That's why we have co-signers. Parents will co-sign the leases for their students who come into the town to attend college. I think the real crux of the question is, I don't want to rent to undergraduates because of the way their lifestyle, and I'm worried about damage to my apartment. I don't think that is a legitimate basis not to rent to somebody who is otherwise qualified to rent your apartment. It is a risk, I understand that, but I think what you have to do is be diligent as a landlord to make sure you go through with that tenant the condition of the property and your expectations as a landlord under the rules you have under your lease. So examine the rules you have under your written lease with the undergraduate students that you are renting to, and make sure that you keep on top of that without interfering with their rights to quiet enjoyment of the property. That being, you can't go banging on their door every week to do an inspection of the property. However, you can go in, we make repairs, and if you see things that are in a condition that were not as they were when you rented the apartment, then you have a potential breach of the lease against that particular tenant, the undergraduate. So the answer to your question there is yes and no under certain circumstances.
Right. I think it's important also to note that age is only a protected category for over 40.
Right. That's a good point. It's a very good point. Age is only a protected category for over 40. But this is me as a lawyer trying to analyze it in the thumbnail sketch that you provided. I would think that you couldn't deny someone a housing based upon your anticipation that they are going to ruin your apartment or be a bad tenant. It might be a basis for evicting them.
Yeah, and so we've also got a couple more questions again on sort of this question of an undocumented immigrant, the undocumented tenant, and just that they are fully covered by laws that apply to the rest of the population.
Oh yes.
Though, I mean, again, as we've mentioned, right, while it is illegal for a landlord to retaliate against a tenant, and any instances of that, we would want reported to our office. It's not a trivial concern that the undocumented tenant has that the landlord could report them to some immigration authority, right? And that's...
Oh, yeah, we see a lot of discrimination and violations by landlords against undocumented immigrants by virtue of the fact they're undocumented because they feel they have leverage over them. A lot of this occurs in gentrifying neighborhoods when they want tenants to leave early, and they, short of threatening them with calling immigration, they will let them know that they don't have rights to stay, and they know that they're scared already by virtue of their status. That's something we would want to know about and see if there's anything we could do to help the tenants out or to stop the practice from happening, particularly if it's happening on a wide scale with a particular landlord or a particular neighborhood.
Right. It's absolutely something we would want to hear about here, either by filing a complaint or just, most of who we have here are service provider organizations by following up with us and letting us know we can get you to the right part of the office. So another advisory that we put out recently, lead paint discrimination, and advisory both for landlords and tenants. Again, the landlord cannot, because there's lead paint in the property, turn away all children, right? Turn away all young families from the property because they don't want to have to go through the mitigation procedures. And again, I think if that's something that we're seeing, right, if that's something that you hear about, I think that's something that we'd want reported to our office. Do you have anything?
No, that's a very important issue to report to the office.
Yep, and I'm sure at the end of this presentation we can send this flyer out in addition to the PDF of the PowerPoint.
Yep, we'll be sending a PDF of the PowerPoint as well with the 2 flyers that you just received. We'll also be sending out a survey. If you don't mind taking a minute to fill that out, it really does help us create a better webinar presentation. So thank you.
So this just I'll jump really quickly. Some general hotlines, general numbers that we have are consumer hotlines. So for most tenants who may be having an issue, may have a question, they can call our consumer hotline. It's at 617-727-8400. That's our consumer advocacy and response division. We call it CARD. They're open from 10 to 4, Monday through Friday. That's those times you can reach them. Of course, you can always file a complaint online. That doesn't go down at any point of the day if you are interested in that. Specific hotlines, we have CARD there. Again, it's just a different number to reach them at a time. That was a different number for a different division that has since merged. Not that any of that is important information for those people on this PowerPoint, but just so you know why we have 2 different hotline numbers there. We have an elder hotline. This is, if you know a senior who may need a little more time on the phone, doesn't want to be rushed, may need a little more hand-holding going through the filing a complaint process, they can call our elder hotline and get more time to speak to somebody there. They might not reach someone right away, but they will get a call back. Our Fair Labor Division, as Magani mentioned at the top of the presentation, if there's any wage issues, you're not being paid, right? A lot of these issues go hand in hand, right? It's very clear that someone who's having a housing issue may be having issues in other areas of their life as well. Our Fair Labor Division, you can file a complaint with them. Our Civil Rights Division, we mentioned already, and just some tip lines and fraud tip lines there as well, which are less sort of consumer-facing, but if you do know about that happening, please let us know there. So I think with that's all the content, again, that we have. Again, this is just our main number here and our card hotline. That's all the content we have on this slide. Again, I'm sorry if we didn't get to your question. We really did try to get to as many as you can.
There's one more question I think that we should just answer, and it came from Catherine. It says, is there anything we can say to someone who is undocumented to feel at ease calling your office to make such a complaint? Well, with the Attorney General's office, as long as you live in the state of Massachusetts, as long as you're a resident here, then we are going to assist you. We do not discriminate based on national origin or immigration status. Our office is welcome to everyone that is here in Massachusetts.
And we have a policy that's been going on for several administrations. I know it's this one. We don't enforce the immigration laws. We're not going to report anybody because they're undocumented and they have a complaint with our office. I know there's still a lot of trust issues, and these people who are undocumented probably been through some very horrific experiences with their home government and our federal government. But we're their government too, and we're the government that's going to help them within the parameters of state law. We're not going to go reporting anybody because they're undocumented.
Right, that's truthfully not something we're even going to ask about, right?
Yeah, exactly. We wouldn't
It's
even
not on
ask.
our forms, we're not
Yeah.
going to ask, and that's not something that affects how we do our jobs at all, so we're not going to ask about it. But that being said, we want to be seen as a friend here. We have one more question. Can they anonymously file? If it's just a tip about a general practice, then sure, of course you can file anonymously. It's going to still get treated. We're still going to take a look at it. If it's someone who specifically is asking for help via our consumer division or any other division that may specifically get involved in their individual matter, they can file anonymously, but if we have no way of getting back in touch with them, it's going to be difficult for us to help them out on an individual basis. But again, thanks to everyone for being on the phone. Thanks so much for all your questions. I thought this went really well. We had really good engagement. Hopefully we answered everything that you were looking for to the best of our ability. But if you do, like I've said multiple times, if you have any questions that come up after this presentation, please just let us know. Please reach out when that email comes up with the wrap-up information, and we will try to spend some more time on it and get you an answer to the best of our ability. Anything else?
All right. No, thank you everyone for being on the call and listening to and watching our webinar. It really does go a long way, so we hope that we helped you out.
And what's next?
Next, we'll be having another webinar in September on workers' rights. So we'll be sending out the schedule about our different webinars. We've got webinars until November, so look forward to that. We'll be sending out a flyer with more information about that.
I have two practice tips before we leave, just arbitrarily. One, if you're a landlord or a tenant in a dispute with your respective landlord or tenant, and you're going to housing court in an eviction process, you can expect that you're going to go through a mediation process, mandatory mediation. You should take advantage of that because there are going to be trained mediators there. Could be lawyers, retired judges, other trained mediators who will get to the heart of your matter. And if you really think you're right and the landlord or tenant you're against is wrong, they're going to see right through it. But they do a great job at resolving disputes, and they're not tenant-friendly, they're not pro-tenant or pro-landlord. They're very fair for either side. Second thing is, if you're a student or you help students with off-campus housing, the biggest problem we see happening is when students share an apartment together and the semester ends and people come in for the summertime and they decide they're going to substitute tenants on the lease. They can't do that. Whoever signs the lease is responsible for all the terms and conditions of the lease. So don't expect partial security deposits to be given back before the end of the lease term. So make sure you understand that when you get to agreement with your friends about who's going to take whose bedroom over the course of the summer. You're responsible for that, not the landlord.
All right. Well, again, thanks, Matt. Thanks, Pagani, for being here. Thanks, everybody who was listening. And again, if you need us, you know how to reach us. And if you are interested in our workers' rights presentation coming up in September, you can sign up for that. Thank you.